Welcome to Oil and Gas Law with Energy Law Prof. Today we'll be talking about division orders. Now these division orders are orders that the oil and gas company signs along with the other parties that are getting oil from a well to determine how that's divided up. Now it's important to understand that's not part of the oil and gas lease, and the oil and gas lease is generally the document that determines what share the landowner should be getting from the well. What's their royalty share? Is it that traditional 1/8? Is it something more? But the division order authorizes and specifies how the funds from that well or how the oil and gas is distributed. So one common thing that it might be used for is if under a royalty, as we've discussed, the landowner might be entitled to a share of the oil in kind. So they really get just one of 8 barrels delivered to them at the well. Instead, they can ask the oil and gas company to sell that oil for them, and so that they just get the money instead. So here's one kind of provision you might see in a division order. You agree to pay at your posted per barrel field price, or if the oil is purchased by a nominee, the price shall be the same received from the nominee. And if you do not agree to pay the posted price, the price shall be an agreed price. So that takes that typical oil royalty, which is typically paid in kind, in oil barrels, and says, no, just instead, why don't you sell it for me and give me the money? Okay, here's some of the big issues that arise under division orders. So first is, do you have to sign a division order that says how much of the oil from the well you're entitled to? And often the answer is yes. Often in Texas, the answer is yes. But because you're required to sign that saying, okay, this is the share that I'm entitled to, that's very simple. If it's just one landowner, you're entitled to that royalty share. But it can be complicated if you have lots of different fractional landowners and each of them has a different amount of the oil that they're entitled to. And so sometimes there could be a dispute about whether what the oil and gas company is asking you to sign under the division order is really the same as the share that you are entitled to under the lease. And for that reason, we'll see that generally, because you generally have to sign a division order, that generally actually doesn't change your underlying legal rights. And we'll look at a case on that. So but although it doesn't generally change your legal rights, it can change things a little bit, particularly in how your royalties might be measured in a case like we've seen with natural gas prices, where maybe it's sold under a long-term contract, but you would like to have the market price. That kind of raises this further issue, which is if you accept payments under that division order, are you barred from claiming that those payments actually aren't correct when you look at what you were owed under the lease? And as we'll see, not necessarily. In fact, often you will be able to stand on your rights in the lease. And we're going to look at a case where that was the case, which is Gavenda versus Strata Energy. This case is both useful for the division order discussion today, but we'll talk about it in future classes as well. So it's an important one to keep in mind. So in this case, what happened is that the Gavendas had sold land, and when they did that, they reserved for a period of 15 years an undivided 1/2 non-participating royalty. So this is basically a term interest. We'll talk about those in the future, but it says for the 15 years after we gave you this property, we're reserving a 1/2 non-participating royalty. Okay. So in 1979, 1980, and that's within that 15-year period, right? That's like 12 to 13 years after this initial grant and reservation. Wells are drilled, and the leases reserve a 1/8 royalty. Now, the Gavendas signed a division order, and they said, look, we only need 1/2 of 1/8. And so we're going to get a 1/16 royalty, right? So basically the Gavendas signed something saying, okay, we're going to take 1/2 of the 1/8 royalty. We'll only take 1/16. Now what happens a couple years later, Gavendas say, wait a second, we didn't negotiate for 1/2 of what the royalty is. Go back to that 1967 language. They negotiated for a full 1/2 non-participating royalty. In other words, what that literally means is they should be getting 1/2 of all production from that oil and gas well. Let's think about that a little bit. That's a huge share of production. Remember, typically, even the landowner only for many years would get 1/8 of production from the well. So there's this other party that has a non-participating royalty interest, not even on the land, and they say, I want a full 1/2 of production. We'll think about that a little bit more in a second. But here's the problem. They signed a division order that said they were only entitled to 1/2 of 1/8, so 1/16 of production from the well. Now they're saying, well, actually, if you look at our real interest, it was a full 1/2, not 1/16. And so we want, for those couple years of production before my 15 years interest ran out, we want you to go back and give us a full 1/2 of production. And the Texas Supreme Court here holds that the Gavendas can recover because basically they say, look, this division order was not consistent with what their actual non-participating royalty was. It wasn't 1/2 of the royalty. It was simply a 1/2 royalty. Okay, so what's actually going on here? Let's think about this from two perspectives. One is, why did the oil company, when it was preparing a division order for the royalty holder and for Gavendas to sign, saying how the oil from the well would be distributed, how could it make this mistake and think it was 1/2 of 1/8, not a 1/2 non-participating royalty as it says? Okay, so think about that for a second. But I want you to also think about it. How could the Gavendas have made this mistake? I mean, they had a 1/2 non-participating royalty, and they signed a document saying, oh, actually, we only got 1/16. And they got 1/16 for a couple of years until they realized the mistake and went back and corrected it. So how could this mistake have been made? Well, let's think about this. What did everybody think was going on? I think what everybody thought was it was going to be a 1/2 of the lease royalty. Everybody acted until 1982 as though that previous document hadn't said 1/2 non-participating royalty, but had instead said 1/2 of all oil royalty or oil and gas lease royalty. The reason they likely thought that is probably the most common non-participating royalty that a seller of land would reserve for him or herself. And that's because in Texas, if you're selling land and you think you're selling it for the surface to somebody who wants it for the surface, you might have some suspicion or some concern that in fact they want oil and gas production from it. And how you protect yourself is you say, okay, if there's production on it in the next few years, I want a share of that oil and gas production. I don't want to find out that I accidentally sold this land without realizing there was a lot of oil and gas on it. And a common way to reserve that production would to say, I want 1/2 of whatever royalty is paid on that land in the future. Now, that's not what the Gavendas did here. Instead of asking for 1/2 of all lease royalty in the future, they just asked for a 1/2 royalty. How common is that? That is very uncommon, because what would happen if there was a piece of land where everybody understood that 1/2 royalty was owed to somebody who was not even on the land, a full 50% of all production? That land would be very unlikely to ever be developed for oil and gas, because oil and gas companies, particularly back in the 1980s, were used to getting 7/8 of production. So if they were in a situation where they had to give 1/2 of all production to the Gavendas plus something to the landowner, there would be very unlikely to be enough left over for the oil and gas company to make it worth it. And so in reality, that kind of a non-participating royalty that big, 50% of all production, it's probably worthless because nobody would develop the land. What would they have done instead? Well, they just would have waited till 1982 when the interest expired and go ahead and lease and drill then. So what the oil and gas company and possibly the Gavendas thought is this was the typical 1/2 of lease royalty that you see from non-participating royalty interest. And neither party realized, wait a second, this is actually a very unusual and bizarre situation where somebody has reserved a full 50% of whatever production occurs on the land. But the important point, and we'll come back to that interesting difference between a 1/2 of royalty versus just a straight 1/2 royalty. We'll talk about that in future classes. But for purposes of this discussion of division orders, all you need to understand is that the division order, which the landowner is generally required to sign so that the oil and gas company knows how to distribute the oil and gas, doesn't alter the underlying legal rights. Now, the one sort of exception to that the courts have recognized is discussed in this Middleton case, which is from 1981. It's discussed both in the Gavenda case in your book, but it's also discussed in the notes afterwards. And in that case, what happened is that the division order prescribed a different method of calculating what the natural gas royalties was. And it didn't necessarily make it bigger or smaller in general. All it said was, we're going to determine it under the contract price rather than the current market value. Now, that is fundamentally a change to what was done under the lease. And so it's interesting that in that circumstance, the court said we can go with the division order rather than what's actually specified in the lease. And so for that reason, it's very important that the oil and gas company is going to ask the lessor or the royalty holder to sign a division order. And it's very important to review that division order, because although we've seen from this Gavenda case that the division order maybe can't change your legal rights in a big macro way, it can change the way that your natural gas royalty is measured, and that can have an impact depending on what the difference is between the price of natural gas under that long-term contract and whatever the current market rate is.